Good morning. My name is Richard Jolly. I am a practicing attorney at Sussman Godfrey in Los Angeles, California, and I'm also a research fellow for the Civil Justice Research Initiative at UC Berkeley School of Law. It is my absolute pleasure to welcome you to the second in a series of Berkeley Boosts webinars sponsored by the Civil Justice Research Initiative. You can learn more about the work of the CJRI, including its diverse research and public programming, by visiting our website at civiljusticeinitiative.org. The goal of this webinar series is to explore the impact of important issues currently facing issues in civil justice. With each episode, we will offer perspectives from legal practitioners and those in the legal academy. Today's episode will focus on civil remedies for police brutality, focusing on how civil litigation succeeds or fails to affect meaningful change and what more we can do to address this issue. To offer a few words about the CJRI and introduce our guests, I'm excited to welcome and to turn it over to Chair of the Civil Justice Research Initiative and Dean of Berkeley Law, Erwin Chemerinsky.
Thank you so much, Richard, and welcome to everybody. I want to very much thank Ann Bloom and Richard for arranging this program. I especially want to thank the two speakers I'll introduce in a moment, Jeannine Bell and Paul Hoffman. The Civil Justice Research Initiative was created a few years ago. It's meant to provide a university-based research initiative to look at aspects of the civil justice system. Of course, nothing is more important right now than the ability of the civil justice system to deter police misconduct and to provide compensation for victims of police abuse. And that's why I'm so glad that this program is happening today. I want to introduce the two speakers. We couldn't have two better speakers to address this topic. The first is Jeannine Bell. She's the Richard S. Melvin Professor of Law at Indiana University Maurer School of Law. She is one of the leading experts with regard to policing and hate crime. Her most recent book was titled Hate Thy Neighbor, Move-In Violence and Persistence of Racial Segregation. Her earlier book was titled Policing Hatred, Law Enforcement, Civil Rights, and Hate Crime. She's won a number of awards, including the Leon H. Wallace Teaching Award at Indiana University. For a year in 2005-2006, she was an American Bar Association visiting scholar. She will speak first and then turn it over to Paul Hoffman, who's one of the leading civil rights lawyers in the country. Paul is a visiting clinical professor at University of California, Irvine, where he's directing a civil rights clinic. He's a partner in the law firm of Schoenbrunn, Seplow, Harris, and Hoffman. He has litigated many police abuse cases. For a time, he was the legal director of the American Civil Liberties Union, and he was also on Amnesty International's executive committee. I have said in print that Paul is one of the very best lawyers I know. I've had the great pleasure of serving as his co-counsel when he's argued major international human rights cases in the Supreme Court. And if I have a case in the Supreme Court, the first lawyer I call to be my co-counsel is Paul Hoffman. So with that, I'll turn it over to Professor Bell and then Professor Hoffman.
All right. So why are we going to talk about civil remedies for police brutality? Why does it make sense to talk about civil remedies? One of the reasons why it makes sense to talk about civil remedies is because the criminal law largely fails in holding officers accountable for their use of force, even when their use of force is caught on video and results in an individual's death, right? Why does this happen? There are a couple of reasons why this happens. The first is prosecutors. Prosecutors are very reluctant to charge officers who they need in other cases. So a lot of cases, the vast majority of cases, never even get charged. In cases that do get charged, and I'm going to mention a few high-profile cases that you've definitely heard about, there aren't convictions by and large. So this is part of the reason. So quickly, a few big cases that you've heard about. First, the case of Freddie Gray. Baltimore's one of Baltimore's certainly most famous cases. In that case, the charges were dropped. right? The charges against the officers who ended up killing Freddie Gray were dropped. So it never even saw the inside of the courtroom for a second. The 2015, the second case, the 2015 case of Michael Slager, who killed Walter Scott. This is one of the first bystander video cases. There were charges in this particular case. It went to trial, and it resulted in a hung jury. This is a case in which African Americans were on the jury, right? But again, couldn't secure a conviction in this particular case. The case of Walter Scott, if you're not remembering back 5 years ago, this involved the individual who was, Walter Scott was running away and shot in the back by the officer. A very high-profile case, the Ray Tensing case. Ray Tensing killed an officer, a university police officer who was off campus, killed Samuel DeBose. There was a video in this particular case. Ray Tensing wasn't convicted. And in fact, and this the civil law comes in here, not for Samuel DeVos, but for the officer. He won a lawsuit for $200,000 in back pay and $100,000 in lawyer's fees because he'd evidently been improperly fired by the University of Cincinnati.
So the police officer sued the university for firing him after he shot someone.
Yes, absolutely, and won, right? And the final case that I'll mention, the 2016 case, is a case of Betty Shelby in Tulsa, Oklahoma. She shot Terrence Crutcher. This case went to trial. There were videos. There were African Americans on the jury, multiple African Americans on the jury. She was acquitted, and she returned to working in law enforcement. So if you want to send a signal to officers and departments that they will be held accountable for improper use of force, you cannot say that the criminal law is a slam dunk. Absolutely not. So it's important to look elsewhere.
It's the criminal proceedings are routinely failing. Paul, you've worked in civil litigation on these types of issues. How do police brutality lawsuits typically work, and are they any better than the criminal proceedings that are routinely failing, as Jeannine was just explaining?
Well, maybe I could start with that first. I think that one of the reasons why it's important to have a system of civil remedies for police abuse is, in fact, the failings of the criminal justice system in holding officers to account. And that's a failing that's gone on for decades. And so one of the purposes of the civil justice system and the main tool in the arsenal of civil remedies is the Section 1983, 42 U.S.C. Section 1983, which is the main civil rights statute that dates back to 1871. And it enables anybody to bring a case for violation of their constitutional rights, which is what is involved in most of the police abuse cases. There are similar remedies in states, for example, in California, where I practice, but elsewhere too. But the purpose of them, there's a lot of purposes, but one purpose is to hold officers to account in ways that the criminal justice system doesn't. Another purpose of them, and it's part of the same accountability system, is to get information. There are a lot of times when the police are not forthcoming about what happened in situations. And so it's extremely important to to bring suits, to use the discovery system to find out what happened, to get the relevant documents, to take depositions of the officers, and hopefully to make that information public so that the community is involved in holding officers and departments to account. I think also it enables the victims of police misconduct, both the living victims and the relatives of people who have been killed, to be heard, to feel like they have access to some form of justice, which they actually have a lot of control over as compared to relying on prosecutors in criminal cases. And they can go before a jury of the community, and the jury can make an assessment of the police actions in question rather than rely on the administrative procedures within police departments that are weighted to protect officers and not to give justice to people in the community. And then, of course, there's compensation for the victims who've suffered injuries, who have suffered the death of a loved one, which offers some justice to the victims, but also cumulatively at least has the possibility of causing decision makers of various kinds within cities and counties to change practices, which is obviously the goal of the whole system. And I can give at least a couple of examples of that, which seem pertinent now. That after the Rodney King beating, one of the reasons why there was the Christopher Commission, a commission about police accountability, one of the reasons given was because of all the judgments that had been issued against the city and the need to look at reform to avoid that. And that was the same for the LA County Sheriff's Department, which about a year later had created a similar commission. And the express purpose of that was that there had been a series of major civil judgments in connection with wrongful death cases that led them to create a similar kind of reform process. And so, it's an imperfect system. And I think maybe the next thing to talk about is the problems in the system, because the civil system has its own set of problems. But that's the reason for it. And I think it does sometimes work to hold individual officers accountable and to create some kind of change within various police departments.
Absolutely. So when there is civil litigation, we actually might realize some amount of change. For instance, following the Rodney King beatings, we saw commissions organized, and it brings to light and to public some of these horrible acts. But that's kind of the issue. Can we even get to the public? Can we get to a trial or to a jury? I mean, that seems to be perhaps one of the biggest problems facing civil litigation. And as we've seen before, it's as Jeannine was saying, it's a problem using the criminal system as well. Can we even get this to a place where these types of cases, to a place where the public gets to see them? And what type of hurdles are there that are preventing us from doing so?
There are a lot of obstacles to these cases, but not in all cases. I mean, I think one of the biggest obstacles is the various immunities that officers and others have in the civil system. And the one that's become one of the most difficult to overcome is the concept of qualified immunity, which says that police officers can't be held to account unless they have violated clearly established law. And the Supreme Court has ratcheted up the meaning of that to the point where if an officer hasn't violated the law in the same way that someone else violated it and was found to be unconstitutional by a prior case on point, that they escape from liability. And I know that one of the things pending in the House Democrats bill and it's actually an issue that both sides of the political spectrum are concerned about, to try to do away with qualified immunity or to reduce its effect. But it's been one of the main obstacles to getting to trial. In a lot of cases, though, for example, wrongful shooting cases, many of those cases actually do go to trial and are not as affected by qualified immunity because there are fairly clear standards, and the question is whether the officers have violated them or not. One of the other obstacles that is difficult, I think, is it's very difficult to get injunctive relief, in other words, relief against future misconduct, in some very key circumstances. And the best example I can think of that is the Chokehold situation in Southern California, where in a period of a few years prior to, I forget the date actually, there was a period of time when African Americans were being stopped by LAPD officers and were being choked to death in very large numbers. I mean, a couple of dozen people. And there were a number of civil judgments in those cases. But when the plaintiff's lawyers tried to get an injunction against the use of the chokehold, they were met by another legal obstacle, which was that because there was nobody that could allege that they were going to be choked in the future, there was no basis for injunctive relief. And that was from a Supreme Court case called Lyons versus City of Los Angeles. Now, what wound up happening is that the publicity around the damage suits and all the publicity about this practice led the police commission to actually change the practice. And so there's a lot of times when civil litigation works hand in hand with political activism to make changes in policy, which we hope obviously will make some changes now too.
On that,
yeah, Jeannine.
On that issue of the chokehold, I read in a book about the LAPD written by a famous police scholar that Daryl Gates had said about the chokehold. Former LAPD chief had said about the chokehold. It was a strict cost-benefit analysis. He'd rather pay in losing damage suits than eliminate the practice. And, you know, he said he was perfectly comfortable paying as opposed to eliminating the practice. And this is part of course, the warrior cop mentality that so pervades policing today, and it's something that needs to be eradicated.
That's fascinating because that suggests that there would be an amount at which, at least I would, perhaps not, but there would be an amount at which if they were forced to pay, they would have to stop these types of behaviors. Are there, the issue with the injunctive relief is that that's a standing issue, right? That's not going to be something that we're going to be able to statutorily overturn. However, if qualified immunity and some of these other things that can be fixed that aren't standing based, and we're able to make higher damages amounts, would that affect, Jeannine, do you think that calculus, you suggest it's this warrior mentality, is there your reading of that, is there a point at which the money would be too much and they would halt these?
I actually don't think so, because I don't think this is rational. That's a rational calculus. And I think that the warrior training, which absolutely pervades policing at this particular point, has so conditioned law enforcement, both leaders and frontline cops, that they are not behaving in ways that are rational in the slightest. So the ability to make intelligent decisions with respect to what costs too much or what is appropriate in a given situation is deeply affected by training that they've received since the very beginning. And this is something that we're just going to have to deal with, in part by eliminating warrior-type training, from the very beginning.
You know, I think in LA, over the years, there have been efforts to to try to overcome that kind of mentality that Daryl Gates personified. And I think it's a combination of activism in the community. It's not just the police department that gets to decide these things. It's the city council, it's mayors who appoint police chiefs that are different over years. And I think that has led to some improvements in LA over the years. Now I think it's a constant battle. I don't think it will ever end. So that's, it's not like there's a solution to this problem, but I think there's a lot of solutions. One other one that I wanted to mention, which I think is important, is that in the aftermath of the Rodney King beating, we made requests to the Congress to give the Justice Department pattern and practice authority, which they didn't have before. And in fact, Congress passed a law that gave the Civil Rights Division of the Justice Department the ability to bring pattern and practice suits, which gets around the Lyons problem, by the way. And in fact, certainly during the Obama administration, that authority was used to a great degree. And in fact, Los Angeles was under a consent decree, Pittsburgh, probably 20 or so cities, police departments were under consent decrees that we forced them to create fairly substantial reforms along these lines. Now, one of the things that's happened since is that one of the things Jeff Sessions did when he was Attorney General was to basically say that he would not enforce any of those laws, that he would not enforce any of those consent decrees. And the Justice Department has basically stood down for the last 3 years in terms of using the authority that the federal government has, both the criminal authority and the pattern and practice authority, to do anything. And so one of the things that I think is going to be crucially important is to have a Justice Department that uses that authority effectively to make the kind of changes that are necessary in departments across the country. And that's, again, it's just one tool, but I think it's a very important tool that the federal government has to overcome local resistance to police reform.
As we start looking at the ways that there are both formal and informal tools to affect change in police tactics and brutality, are there others that either of you can think of? We can see that the publicity can do a lot, but that publicity can do a lot to get consent decrees. But if no one's going to be enforcing those consent decrees, we're going to still have problems. Is there something more structural that we can be looking at?
Yes, I think so. My work suggests that police officers have too much of the wrong kind of contact with citizens. So I'm a big fan of the Defund movement with a caveat, an important caveat that's not often talked about. When you have fewer funds, when a police department, an individual police department has fewer funds, you have to concentrate what you have left by ending sort of practices like broken windows policing, ending stop and frisk problems, ending investigatory traffic stops, and devote some of the resources that you put into those old programs, which didn't work. The empirical data is quite clear about the fact that none of those programs helped catch the criminals that you thought they were going to. You have to put the energy and the resources into investigating very serious crimes, homicides in marginalized communities. Roxana Altos at Berkeley talked a little bit about the number of homicides that don't go investigated in the Black community in Oakland. So you need to shift resources in ways that see individuals in marginalized communities as victims of crimes as opposed to just perpetrators of crimes. And I think that that will help to change the relationship between the police and the community. So protect and serve, we need to put the emphasis on serve by actually investigating crime.
You know, one of the examples of that, I think, at least in the work that I've done over the years, is the need for more resources for mental health support. Right, you have a lot of police shootings happen when people call for the police to come to help them with a family member that has mental health problems, and it ends up in a police shooting. It seems to me that if there are more resources for mental health professionals to deal with those kind of situations, you would eliminate a lot of those situations and do a lot of good for the community. So I think it's one of the examples. You know, there are a lot of specific things also that could be done to restructure police. For example, in New York, they just changed the law with respect to the confidentiality of police officer records. And I think that's a problem across the country, that we really don't have an insight into. And look at the guy that killed George Floyd, had 28 complaints. I mean, those things should be surfaced before an officer kills somebody. You know, they should be dealt with within the system in an open and honest way. You know, it doesn't mean that everybody would necessarily be fired, but they certainly should be retrained or dealt with. And some people shouldn't be police officers, and they should get them out of the police departments right away. So confidentiality is a huge issue, and I think that can be changed legislatively, as New York has indicated. And there's a lot of scope, I think, for state and local legislation to make up for some of the problems that we see with an increasingly conservative Supreme Court. For example, we have a taxpayer statute in California that gets around the standing problem. Any taxpayer can sue for the illegal expenditure of tax funds. And that means if there's a practice like chokeholds for which there's no standing in federal court, any taxpayer could bring an action to deal with that practice. And that's the kind of thing that can happen in a state that can't happen because of justiciability rules in federal court.
Speaking of the ways that states can change these types of practices, we have a question from the audience asking about no-knock warrants and if how many states and jurisdictions use them and how that might impact lawsuits. Can either of you speak to that issue?
No-knock warrants are pervasive. They are in lots of jurisdictions. And the police argue, and the police will fight hard. Police unions will fight hard on no-knock warrants because they argue that they are needed. One of the places in which you can put pressure on no-knock warrants is no-knock warrants have to be issued by people, right? Magistrates and judges have to issue no-knock warrants. They are not automatic. So local activists can put pressure on judges who issue no-knock warrants. Why did you issue that warrant in that particular situation? Why did you think it was warranted in this particular situation? Remember the individuals who were killed by no-knock warrants?
Please let me thank both of you. Thank you, Jeannine. Thank you, Paul, so much for your time and for your expertise on this issue. Also, before we sign off, I want to let everyone know that the next webinar will be held on Friday, July 10th, where we will explore issues of case management during a pandemic, with our speaker being Roman Silberfield of Robbins Kaplan. Thank you again, Jeannine and Paul. This has just been such a fantastic discussion, and I know we have questions still coming in, so thank you so much.